Today, when they went, the day they went to pick the respondents, they picked them from their home. They had not absconded or gone anywhere. They went to the house and picked them up. The only thing they did the extra is beat them up. Mercilessly. The daughter here has got a P3. The registration of the assault on these other respondents who are here could not be recorded. Why? Because it's a cartel of police officers. Any report against a police officer cannot be allowed. They will not. They went to the DCI Langata. I called personally and sent the advocate in court. But for these other persons, even in the stations, they refused to record it in the OB. So if the second respondent fell today, it's another Albert Ojong kind of case. But they will not. So, Your Honor, now that we have found out that their stories are not genuine and cannot hold water, they forget that this must come to Article 19. These fundamental rights are not for the police officers, are not for the state. They belong to the accused persons and suspects whenever they are apprehended by police, so that they are protected. And the court is bound under Article 20 and 21. These inherent rights, these fundamental rights, once the court notices that they are there, the court must start by wanting to grant, not to deny, as the state would come with an affidavit to show you. So, Your Honor, while they say that they have now treated our client, right to treatment, Your Honor, does it exist? Yes. Right to medical services? Yes. So we are saying, Your Honor, while they want them to be investigated, please release this person so that they can also go for medical treatment. Not one that they have created from somebody we don't know, so that they can be treated. You can't go and tell somebody, we want to investigate you, to write your statement when they are in pain, when they are in suffering, and you say that it is free will. It cannot be. Your Honor, now that they are refusing, activate Article 23. 23 says that now we can come to the court, because when they have refused, we come to the court. You are the arbiter. Now that we know that they don't want these people released, Your Honor, please help us. They don't have to be in custody to be investigated. They can report on a daily basis. These are family members who stay in the same house. They live together. This is mother and son. But they are being told, because some people used a motorcycle and they absconded, and they disappeared, that these people will help them to run away. The people have run away. The people were not found at the scene. But you are being told, please, these people know who they are. It is not true. But you are being told, evidence is strong in this case, and therefore use that evidence to deny these persons to go home. Your Honor, Oyambo versus Republic, I am repeating, Court of Appeal, case number 113 of 2018. What did the court say about that? The evidence that is being brought to you and being told that they were identified and that they were at the scene and they did all these things, Your Honor, cannot be brought into this court, cannot be tried at this particular stage, and therefore the truth cannot be determined at this particular moment. And the Court of Appeal said it is unfair to ever try to use that situation. Do they have a Court of Appeal decision higher than that? Let us not use an issue of what they call probability, because, Your Honor, the fundamental rights are as exact as they can be. They are not probabilities. And you're being told, because there are multi-agencies that are being used, therefore, please give us 30 days. So what, Your Honor? Multi-agencies are who? They are officers like anybody else. Those multi-agency officers can go to and investigate what they are investigating. If they are dealing with data, whatever they are dealing with, they can go ahead and do it. It does not require 30 days. It does not require these people to be in custody. Now, Yana, I'll just mention, before I leave it to my colleagues, I'll go to paragraph 13 of the notice of motion, paragraph 13 and 14. And you're being told that the deceased, while she was driving on 7th of July, she was driving along Gong Road near Junction Mall, 2 unknown men. Yana, that is the catchword. 2 unknown men riding on a motorbike pointed a gun at her. She then ran away and filed a report. You're on 7th of July. Today, we are on 31st. After this incident, the deceased reported to the police and her husband, and that the pilot passenger who was among those was identified as the second respondent. Identified by who? From 7th to 31st, why hadn't they arrested him for that issue? Why are they making it so dramatic now and bringing up an issue that does not exist? Where is that statement where she identified and mentioned that it was Chris who is here in court today, so that we have it and know that it is true? Your Honor, this cannot be true. And that on 27th, while driving from a homestead, she was trailed by unknown men. Your Honor, unknown. Everything is unknown. So because some people who had a motorcycle had a gun, which has not been found with the second respondent, so they should carry the cross. Because the police are incompetent, they cannot investigate a matter from the 7th until today. If they cannot do such a simple matter of a threat from 7th until 31st, what are they asking 30 days for? They can do nothing. And I'm repeating again, please do not allow these respondents to go back to those policemen. They'll be beaten. It is given.